Good morning, ladies and gentlemen. This case was about killing for the sake of killing. He told detectives, I've already done it once. I'll do it again. But it's not about that he killed. It's about how he killed. Blunt force trauma in compliance for submission. Strangulation for silence. According to him, it only takes 2 minutes. He doesn't get scratched. He doesn't get hurt. They don't yell. They're quiet. They can't get away even if they wanted to. He's too strong. Those are the people he goes after. On the 7th of October of 2019, he went after Christine Melton, he went after Melissa Montanez, and he went after Diane Lewis. Only one survived that day. Only one. Why? Because there was too many people around. But if you remember what he said, he would have killed her too if given a chance. Now, what I expect the court to do is give you a series of instructions. What we need to prove to you that he did everything that we've charged him with. We've charged Mr. Wilson with first-degree premeditated murder. We need to prove that Christine Melton is dead. There should be absolutely no doubt in your mind that Miss Christine Melton is dead. You heard from the medical examiner. You heard from Miss Christine Johnson. You even heard from Mr. Wilson himself. Christine Melton is no longer with us. Second thing we need to show is that the death was caused by the criminal act of Mr. Wilson. There should be absolutely no doubt in your mind that Mr. Wilson did these things. All the evidence corroborates what Mr. Wilson has told you in the course of the past day or two. And lastly, ladies and gentlemen, there was a premeditated killing of Miss Christine Melton. And what's interesting about the premeditation instruction, it says killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing, and the law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant, and the premeditated intent to kill must be formed before the killing. So, that's a lot of words. Let me make it simple for you. When one is sitting outside in the evening time, and it's humid out, and a mosquito lands on your arm, you look down, you decide to kill that mosquito. That's premeditation, ladies and gentlemen. Because the law does not fix a period of time. You can go from that short period of time to as long as you want. Planning, whatever you want. But when we're talking about premeditation as it relates to Ms. Melton, ladies and gentlemen, it's also going to apply to Mr. Weiss. Strangulation is the epitome of life slipping through someone's hands. Premeditation starts by placing the hands on the throat of another. The application of pressure. Squeezing the throat, not releasing until there's that one final breath that remains in that person. And what's interesting about that particular act, ladies and gentlemen, is that both people know that one person is going to die. So when Mr. Wilson decided to go ahead and inflict blunt force trauma upon Ms. Melton, you heard about it. The broken nails, right? She was a fighter. She knew what was happening. We also know what? The lungs, the colon, the bladder. What else? The liver. You heard about the brain swelling from Dr. Coyne? She was alive when all that happened. Couldn't happen after she was strangled. And then what do we also know? We also have compression of the neck. 2 marks. The deep hemorrhages that Dr. Hernandez talked to you about. Dr. Coyne and Dr. Hernandez told you that was all consistent with asphyxiation. It's another term for strangling. So, ladies and gentlemen, that is premeditation. That, ladies and gentlemen, is first-degree murder. Well, what do we know happened next? Well, we have to prove grand theft of a motor vehicle, right? Grand theft of a motor vehicle is Mr. Wilson knowingly and unlawfully obtained or used endeavor to obtain or use a motor vehicle Christine Melton. You saw that black Nissan Versa. You know it belongs to Miss Christine Melton. Her registration's in there. Her tags are in there. Her phone is in there. Stephanie Johnson identified it as her car. When did he use it? After he killed her. So, yeah, he unlawfully obtained or used her car. That element's been met. 2, he did so with the intent to temporarily or permanently deprive Miss Melton of her right to the property or benefit to it or from it and appropriate that property of Christine Melton to his own use or the use of another person entitled to it. Yeah. Did that too. And 3rd, the stolen property was a motor vehicle. And you saw it on Mr. Lukash's video. rolled up in it. It's clearly a motor vehicle, ladies and gentlemen. I submit to you, that charge has been proven as well. But where does he go to from there? Well, after he's gone ahead and killed Miss Melton and taken her car and held her face up to utilize her phone, he makes a whole series of telephone calls, right, to Miss Montanez. Hey, I need to see you. Where are you at? Calling her repeatedly. Miss Lavoisian told her, don't bring him here. Tell him you meet him at your spa. Well, ladies and gentlemen, that's why we showed you phone records. The 630-962-1256. Miss Melton's phone number. We also have Miss Montanez's phone number at 239-333-5924. And also what comes up later is this 239-200-8319 number. The reason why these phone numbers are important, ladies and gentlemen, is because when you look at the phone records of Miss Montanez, okay, on page 1 of 6, you're going to see 200 numbers. You're going to see the 333-5924. You're going to see 333-5924. You're going to see Ms. Ruiz's phone number in Ms. Montanez's phone records. There's no reason why Ms. Melton, let alone Ms. Ruiz's phone, should be in Ms. Montanez's phone records. The only reason why we showed you that was to corroborate what was happening that morning. He was utilizing Ms. Melton's phone to contact Ms. Montanez. And not only that, ladies and gentlemen, is when he couldn't use Ms. Melton's phone any longer, and he got a hold of Ms. Ruiz's phone, that's when her number starts popping up on Ms. Montanez's phone records. It corroborates what Ms. Montanez was telling you. He is calling, and he is repeatedly trying to get a hold of her. But what's interesting, ladies and gentlemen, is after he gets a hold of her, he just doesn't want to find out where she is or what she's doing. But what does he do? Tries to pull her into Miss Melton's car. He almost runs her over by getting out, attacking her, trying to pull her clothes off of her, beats her repeatedly. She's chased up the stairs. He held her up against a wall with her throat. He punches her in the face until blood spatters all over the place. You saw the photograph of Miss Montanez. You heard the testimony of Miss Montanez. You heard the testimony of Miss Lavoisian. You heard the testimony of Miss Williamson. You also heard the testimony of Miss Griffin. There should be absolutely no doubt in your mind that he committed an attack or a battery upon Miss Montanez. And the only thing I need to show for battery is that he actually intentionally touched or struck Miss Montanez against her will. There's no way that she consented to that. Absolutely, it was against her will. What was she doing? She was screaming. He was threatening. Fortunately for Miss Montanez, she survived. But if given the chance, she'd have been dead. But there's too many people. At least that's what he told us. That brings us to his next victim, right? After he gets done with Miss Montanez, he takes off in that vehicle. There's too many people. He heads to Cape Coral. He comes across a young lady who's on her way to work, dressed in a light blue shirt, jeans, dark shoes. Lures her to the car by feigning to ask for directions. Somehow manages to get her inside the car. Breaks her nose. He breaks her thyroid and neck cartilage. He also runs her over repeatedly. Why? Because after he had choked her, he claims that she somehow was still alive because she also was a fighter, ladies and gentlemen. She had multiple rib fractures. Dr. Coyne told you there was no way, left unattended, that she would have been able to survive. And he ensured that that was going to happen, that she did not survive. Why? Because he's the one who placed her on that empty lot, under those shrubs, under that tree, to make sure that no one would find her. Luckily, when law enforcement was looking up in the sky and just happened to be in the area and they saw that single vulture that was circling, that's what led them to finding Miss Ruiz. And how was she identified, ladies and gentlemen? Jeez. She was decomposed after only a couple days of being out there. Insect activity, animal activity, weather. Her husband had to identify, or fiance had to identify the ring. They identified her by the tattoo on the back. Diane Lewis is dead. Death was caused by Mr. Wade Wilson. And there was a premeditated killing of Diane Ruiz. Once again, ladies and gentlemen, strangulation, placing the hands around someone's neck, and watching that life slip through the hands, and the other person seeing their life leave them. Premeditation. There should be absolutely no doubt in your mind that this was first-degree premeditated murder. He even told you in his statement. She was scared. She wanted to be dropped off. If you listen real closely to that statement, he also said he knew he wasn't going to drop her off, he was going to kill her. He already had it in his head. Why? Because he already killed once before. He was going to do it again. And true to his word, he did. So, ladies and gentlemen, I submit to you, we've established first-degree premeditated murder with Diane Lewis. Where does he go from there? He goes to Joe's Crab Shack, right? Because Officer McCormick received information regarding the battery, Miss Montanez. He's confronted there. He plays dumb. He doesn't know anything about a battery. What does he do? He leaves. He's not sticking around for that. Nope. Where does he go? He goes to Mateo Graphics. One of the other people he knows. Mr. Lukic. Hey, can you help me out? I need a plane ticket. I need a taxi. I need to get out of town. Why? Because I just killed people. I just killed some people. He was frantic. He only had a pair of pants on. Blood on him. No shirt. No shoes. Law enforcement gets there. What does he do? He doesn't stick around. He leaves. Where does he go? He goes to the Amlin residence, right? Unfortunately for Miss Amlin, she left with her husband back to Columbus, Ohio. And he's decided that he needs to do something, right? What does he do? He enters the structure owned or by or in the possession of Fanny Amlin. We know that. How do we know? You saw the broken window. You saw the screen removed, right? He gets in. He gains entry. At the time of the entering structure, he had the intention to commit theft in that structure. Of course he did. He helped himself to some food. He helped himself to some drink. There was different clothes that were laid out. He needed to figure out what he's going to do. What does he do? Contacts his dad. Hey, can you help me out? I need to get out of here. Can you send me an Uber? I need your help. Dad's conflicted. Dad, fortunately enough, does the right thing. He contacts law enforcement, and he contacts Mr. Wilson and encourages him to give the address and location of where he is. But while Mr. Wilson is in there, like I said, he commits petty theft. Because he knowingly and unlawfully obtained or used or never obtained or used the property of Fanny Amlin. You saw the White Claw, seltzers. You saw the various food that was laying there. You saw the clothing that was laid out. You saw the backpack. He did so the intent or eatery firmly to deprive Fanny Amlin of her right to property or any benefit from it, or appropriate the property of Fanny Amlin to his own use or the use of any other person not entitled to it. He didn't have permission to be in there. He didn't have permission to utilize any of the items that were in there, and he didn't have any permission to do anything inside that residence, let alone endeavor to use it, obtain it, deprive Miss Amlin of it. Nothing. So, ladies and gentlemen, we submit to you. We've established burglary. We've also established theft. Now, ladies and gentlemen, in the past 2 days, you've seen and heard a lot. Okay. What we're asking you to do is to take all of that and put it together. We submit to you that you should only come up with one conclusion and one verdict in this particular case. Because, ladies and gentlemen, this case was never about Mr. Wade Wilson. It's about what Wade Wilson did to Christine Melton and Diane Lewis. And make no mistake about it, despite his bragging, his boasting, and the excitement he wants to feel, this case was nothing more than a graphic, vulgar display of power. And we're going to ask that you find Mr. Wilson guilty of first-degree premeditated murder for killing and strangling Ms. Melton. We're asking that you find him guilty of grand theft of a motor vehicle for stealing and taking Ms. Melton's car. I'm asking that you find him guilty of battery for striking Ms. Montanez against her will. I'm asking that you find him guilty of killing and strangling Ms. Diane Ruiz and basically committing blunt force trauma by running her over and trying to make her look like spaghetti. I'm asking that you find him guilty of burglary of a dwelling for going to and breaking into the Amlin's residence, and also for petty theft for taking and helping himself to whatever it was inside that allowed him to do the things that he did. Thank you very much for your time. Yes.
First, on behalf of myself, Mr. Shirley, and even Mr. Will.
Yes.
First, on behalf of myself, Mr. Shirley, and even Mr. Wilson, I want to thank you for the attention you've given through these proceedings. I know there's been some portions that have been rather rough, so thank you. I want to get up here and I want to argue about premeditation. I mean, not arguing whether these ladies are dead. We're not arguing, but the premeditation. First off, let's go through the timeline. He and Jason Shepard meet Miss Melton and Amy Slobodian, I think her name was, at the Buddha. He goes home, leaves Melissa Montanez, his girlfriend, there, takes her car, and apparently Jason drove them back to Miss Melton's house. They have sex. They have consensual sex. Jason Shepard said so. And then something happened. I suspect it was the drugs. Shepard was saying, oh yeah, we were doing cocaine, just not my cocaine. That was for me. Well, if you listen to the statement that was played yesterday, Mr. Wilson talks about using flocka. That is not good stuff. It puts holes in your brain.
Objection, facts not in evidence.
Sustained.
Anyway, at some point between 2 and 4, maybe, Miss Losian leaves, and something goes wrong. Miss Montanez described it. Killer eyes. 2 black holes. No soul, as she put it. Kills Miss Melton. Wraps her up. Why? Rather than premeditation, I would submit to you that the judge is going to give you an instruction on second-degree murder. And one of the, or also known as depraved mind murder. I don't think anyone can argue that none of this was not depraved. But in order to commit second-degree murder, there must be an unlawful killing by an act imminently dangerous to another, no one's arguing that, demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is, quote, imminently dangerous to another and demonstrating a depraved mind, end quote, if it is an act or a series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, no question about that, is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. Whatever he was doing, nobody's arguing was not depraved. Look at the timeline. Miss Melton was murdered sometime between 2 and 4, maybe, when Miss Slobosian left. She had to go to work. Then there's the incident about 7:30, 8 o'clock with Miss Montanez. According to her fiancé, Miss Ruiz was going to work sometime between 9 and 11. She left the house. So the contact between Mr. Wilson and Miss Ruiz is on a road in broad daylight. This isn't some kidnapping in the middle of the night. This is in broad daylight. Again, it's almost a carbon copy of Miss Melton. Again, running over the body 10 to 20 times. Nobody's saying that's not depraved. We're not arguing he didn't do it. There's solid evidence that he is responsible for those 2 deaths and the battery of Miss Montanez. Miss Montanez's testimony, you need to think about that, whether this was premeditated in terms. I mean, Miss Melton had sex with him. He could have just gotten up and left or stayed with her. Instead, he murders her. That's not clear thinking, shall we say. I'm not arguing insanity. I'm just arguing that the state's claiming premeditation, and I'm saying he's whacked out. He's just out of his mind for any of this. The only other point I'd like to make is the burglary. Okay. Burglary of the Amlin house. The second element. At the time of entering, not after you're inside, at the time of entering the structure, Wade Wilson had the intent to commit theft in that structure. No, he was hiding from the police. Remember, this was after the incident with Officer McCormick. He helped himself to the food. I'm not claiming he didn't commit petty theft, but the reason he went into the house is because he was hiding out from the cops. So I don't believe you had a felony. You had a burglary. The judge is going to advise you about a lesser charge of trespass. Again, I respectfully request that you consider whether this was premeditated or depraved mind murder. Now, based on the rules of procedure, I don't get a chance to come back up here. The state does. So I need you to consider what they're going to argue to you in their closing argument, because I don't get a chance to rebut it. I thank you for the attention you've given, and appreciate your assistance in this case. Thank you.
May I please the court? Counsel? Ladies and gentlemen of the jury, this was premeditation all day long. The defendant's attitude toward these women was despicable. He bragged about their deaths to his dad after he killed them. No regret, no remorse. And he replaced the name Christine's mother gave her at birth with the name bitch. I killed a bitch. I choked that bitch out. And 3 days later, he's still bragging about it to law enforcement. And his biggest concern, whether he could get a hamburger and french fries. As Diane Ruiz laid in that field, being scavenged by animals with bugs eating her face to the point where she's unrecognizable, this guy over here wants some french fries. And he's bragging about the fact that Diane Ruiz looks like spaghetti. This is a man with no respect for women, with no respect for human life. When asked about Mila and killing her, he says, there were too many people around. I probably would kill her, you know. You know what I mean, given the chance. Now I want to start with premeditation, because what you're going to see is you're going to see a jury instruction about lesser included offenses. And second-degree murder is a lesser-included offense of first-degree premeditated murder. And there's no doubt that if you read the second-degree murder instruction, you're going to see that it involves ill will, hatred, spite. So there's not a premeditation element, but there's ill will, hatred, and spite. There's no question that he is full of ill will, hatred, and spite. But the law requires you to find for the highest charge. It says when considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that will constitute a lesser-included crime. Therefore, if you decide the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser-included crime. Ladies and gentlemen, you don't even need to go to second-degree murder. You don't even need to consider lesser-included crimes in this case, because the state has met its burden and proven premeditated murder. And I want to start with the defendant's own words about premeditation and how we know that he took a second to think about what he did before he did it. All right, the truth is, I picked the girl up and killed her. I wasn't worried about the school, you know. Remember, this is during the day. School is in session, and it's an elementary school. Little kids being dropped off by moms and dads and buses. I wasn't worried about school, you know. I choked her out until she couldn't breathe anymore. She wasn't fully dead yet. Now, he's choking her. He could have stopped, but he decided to continue so that he could kill her. She wasn't fully dead yet, and she was still alive. And I pushed her out of the car, and she tried to get up, and I ran her over with a car. And I ran over maybe like 10 times, 10, 20 times, her head, her body. He says, I put the window down, and I said, hey, do you know where the high school is, where the school's at? Could you show me? She said, it's right down there. I said, I drove by there, and I didn't see it. Could you please show me? She got in the car. That's all it took. That's all it took. Got her in my car, and then from there, we drove to the school, and I was going to drop her off. But I knew in my mind, I wasn't going to drop her off. There's the mind. I knew in my mind, I wasn't going to drop her off. But she wanted to get dropped off there. I said, okay, you can go. As soon as she went to get out, whatever, I grabbed her by the neck and choked her. That's when I was choking her right there. I was choking her out right there. She came back to life 3 or 4 times. I mean, she was a fighter for sure, I'll give her that. When I pushed her out, she fell out still alive, trying to get up. I backed up and just ran and hit her, ran and hit her, ran and hit her until she was not moving anymore. That's not premeditated murder, ladies and gentlemen. I don't know what is. And after Christine Melton, when he picked up Diane Ruiz, he told the detectives, I was like, you know what? I've already done it once, I'm going to do it again. It came across my mind to murder, just kill, kill, kill. He talks about, I could get sex with her, and then I was going to kill her. This is going to sound weird, I'm just really horny. So I was looking for an easy piece of pussy and saw her walking and she was strolling or whatever early in the morning. So I was like, whatever, I'll give it a shot. When I give it a shot, it usually is 9 times out of 10 works for me. And it did, you know. Fuck it, I should kill her. He says, she did not need a ride afterwards, which is why I started choking her, because she was going to get out of the car. She said, drop me off here at school. I could tell she was getting scared. I saw the fear, and I think the fear triggered me to just kill her. It was going in a weird direction. I could tell things were off because she wanted to be pulled over, and she really wanted to get out of the car bad at this point. And I could tell she was I can sense you, fear. I'm like a fucking lion, and you're the prey, and I can sense it. They can't get away from me even if they wanted to. I'm too strong. I mean, I don't look strong maybe necessarily, but I can't, believe it or not. I'm not trying to be mean. I can take either one of you guys down, and this is what he's telling detectives. He's locked up in the Lee County Jail, confessing and bragging to the detectives about these murders that he committed. Not only do you have his own words, all the evidence shows premeditation. Remember when he told his father about murdering Christine, he says, she's just sleeping there. They had sex. Remember, this is 6 in the morning. Stephanie Johnson has already left. He sees her asleep after a night of going out, having a good time, and he says, I decided I was going to kill her, and I got on top of her. Again, ladies and gentlemen, this is classic premeditation. And there doesn't need to be any length of time. It can be just a short swapping at a mosquito. Defense also alluded that, oh, you know, there's drugs and alcohol, and he was on these drugs. That's what he says. But nowhere in the packet of jury instructions are you going to hear, or are you going to read when you take those jury instructions back with you, that drugs or alcohol is a defense to murder or a defense to premeditation. Stephanie Johnson went out drinking the night of October 6th. She went to work the next day. Jason Shepard went out drinking that night, and he did a line or 2 of cocaine, and he went to work the next day. And Mae Wilson went out drinking. He did a line or 2 of cocaine, and he killed 2, almost 3 women the next day. Using drugs or alcohol as an excuse for injury or death to anyone is insulting. And you'll find nowhere that the law allows that as an excuse. Think about how he was acting. He's at Mateo's Graphics. Why is he there? He's not just out of his mind talking nonsense. No. Our witness, Mr. Lukic, thought he was out of his mind because he's saying he killed 2 women. That seems pretty crazy. He doesn't think that that's probably true. He did, in fact, know it was true. But he's there to get out of town. He's there for a plane ticket or a bus ticket. This is someone who knows exactly what he did. He's not on some kind of drug where he doesn't know, or he doesn't know what's happening or what's going on. He knows exactly what's going on. And he knows he needs to get the hell out of Dodge. And long after the high of any drugs or alcohol could have worn off, he's calling Daddy. Dad, I need you again. I need money. I need to get out of here. I need you to come pick me up. I need you to help me. And he's bragging to his dad, wanting his dad to be proud of the women he killed. And then 3 days later, when he's in custody and he's on no drugs and no alcohol, what does he do again? He's bragging to the detectives. All those quotes I just read you, those were all 3 days later when he has no access to any of that. defense tries to say, he's crazy, he's out of his mind, and the defense, talked about mental health and that being an issue. Again, that's not a defense in this case. There's no evidence of any mental health disorder. There's no jury instruction that's going to excuse him. Any reference of it by the defendant in a statement is simply an excuse to try to justify what he did. He had no issues going out and having a good time at the booth that night. No issues picking up a beautiful young woman at the bar. No issues having sex multiple times. No issues getting exactly what he wanted. He wasn't hallucinating. He wasn't hearing voices. He wasn't confused about where he was. He wasn't confused about anything that night. In his own words to law enforcement, he was a fucking lion and they were the prey. And he could sense it. He liked knowing that they were in fear. He liked knowing that they wanted to get away, and he was not about to let them. And he knew enough that night to give a different name. He was JR, or Junior. He wasn't Wade Wilson, the killer. And he knew after killing someone, he should get rid of the body. He knew that after killing someone, he needed to get out of town. And as he watched the officers search for him, he sat in Amlin's house, drinking White Claw, eating food, using his dad to help him escape. As humans, there's a desire to make sense of it all, to watch the news and come to some understanding of why, to have answers to suffering, and to look for some explanation, to look for a motive, to explain why people do what they do. But that's why the state doesn't have to prove a motive. If you had to sit and find a motive or an explanation or an excuse for Wade Wilson's behavior, you'd be in the jury room for years. Because there's no explanation, no justification, and no motivation that could ever explain the suffering and death inflicted on Christine Melton. The suffering he caused to her best friend, Stephanie Johnson. The suffering he caused to Christine's cousin, Samantha. Or the suffering he caused to all her family and friends. There's no explanation and no justification and no motivation that could ever explain the suffering he caused to Diane Lewis. The suffering he caused to her fiancé, Scott. The suffering he caused to her son, Brandon. The suffering he caused to the rest of Diane Ruiz's family and friends. And there's no justification for the fear and the pain and the injuries he inflicted on Mila Montanez. And any explanation he may have given to law enforcement creates no justification. This defendant is guilty as charged, and we ask that you convict him of all of the crimes the state has alleged. Thank you.
So, ladies and gentlemen, it's a little after 10. Before I read you the instructions, I'm going to go ahead and let you go back for a short 10-minute recess and we'll to give you. Final instructions to control. If I said anything about the law during jury selection or the trial that you think was different from these instructions, you were to follow these final instructions in determining your verdict. Statement of charge. Wade Wilson, the defendant in this case, has been accused of the crimes of first-degree murder, grand theft of motor vehicle, battery, first-degree murder, burglary of a dwelling, and petty theft. Introduction to homicide. In this case, Wade Wilson is accused of first-degree murder. First-degree murder includes lesser crimes of second-degree murder and manslaughter, both of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Christine Melton was killed by Wade Wilson, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. 1. When the killing is committed by accident and misfortune and doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Wade Wilson may be found guilty of first-degree murder or any lesser included crime. First-degree premeditated murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1. Christine Melton is dead. 2. The death was caused by the criminal act of Wade Wilson. 3. There was a premeditated killing of Christine Melton. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. Second-degree murder. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1. Christine Melton is dead. 2. The death was caused by the criminal act of Wade Wilson. 3. There was an unlawful killing of Christine Melton by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that 1. A person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and 2. Is done from ill will, hatred, spite, or an evil intent, and 3. Is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1. Christine Melton is dead. 2. Wade Wilson intentionally committed an act or acts that caused the death of Christine Melton. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Grand theft of motor vehicle. To prove the crime of grand theft of motor vehicle, the state must prove the following 3 elements beyond a reasonable doubt. 1. Wade Wilson knowingly and unlawfully obtained or used, endeavored to obtain or to use the motor vehicle of Christine Melton. 2. He did so with intent to, either temporarily or permanently, deprive Christine Melton of her right to the property or any benefit from it, or appropriate the property of Christine Melton to his own use or to the use of any person not entitled to it. 3. The stolen property was a motor vehicle. Motor vehicle means an automobile, motorcycle, truck, trailer, semi-trailer, truck, tractor, and semi-trailer combination, or any other vehicle operated on the roads of this state used to transport persons or property and propelled by power other than muscular power. But the term does not include traction engines, road rollers, personal delivery devices, special mobile equipment, vehicles that run only on a track, bicycles, swamp buggies, or mopeds. Obtains or uses means any manner of taking or exercising control over property or making any unauthorized use of property. Endeavor means to attempt or try. Property means anything of value. Battery. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. 1. Wade Wilson actually and intentionally touched or struck Melissa Montanez against her will. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. Introduction to homicide. In this case, Wade Wilson is accused of first-degree murder. The first-degree murder includes the lesser crimes of second-degree murder and manslaughter, both of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Diane Lewis was killed by Wade Wilson, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder, second-degree murder, or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. Justifiable homicide. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. Excusable homicide. A killing of a human being is excusable and therefore lawful under any one of the following 3 circumstances. 1. When the killing is committed by accident and misfortune in doing any lawful act by lawful means, with usual ordinary caution and without any unlawful intent. Or 2. When the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3. When the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Wade Wilson may be found guilty of first-degree murder or any lesser included crime. First-degree premeditated murder. To prove the crime of first-degree premeditated murder, the state must prove the following 3 elements beyond a reasonable doubt. Diane Lewis is dead. 2. The death was caused by the criminal act of Wade Wilson. 3. There was a premeditated killing of Diane Lewis. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. Second-degree murder. To prove the crime of second-degree murder, the state must prove the following 3 elements beyond a reasonable doubt. 1. Diane Lewis is dead. 2. The death was caused by the criminal act of Wade Wilson. 3. There was an unlawful killing of Diane Lewis by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and b. is done from ill will, hatred, spite, or an evil intent, and c. is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. Manslaughter. To prove the crime of manslaughter, the state must prove the following 2 elements beyond a reasonable doubt. 1. Diane Lewis is dead. 2. Wade Wilson intentionally committed an act or acts that caused the death of Diane Lewis. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. Burglary. To prove the crime of burglary, the state must prove the following two elements beyond a reasonable doubt. 1. Wade Wilson entered a structure owned by or in the possession of Fannie Amlin. 2. At the time of entering the structure, Wade Wilson had the intent to commit theft in that structure. You may infer that Wade Wilson had the intent to commit a crime inside a structure. The entering or attempted entering of the structure was done stealthily and without the consent of the owner or occupant. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. If you find Wade Wilson guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether the structure entered or remained in was a dwelling. Dwelling means a building of any kind, whether such building is temporary or permanent, mobile or immobile, which has a roof over it and is designed to be occupied by people lodging therein at night, together with the enclosed space of ground and outbuildings immediately surrounding it. For purposes of burglary, a dwelling includes an attached porch or attached garage. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of burglary is trespass. Trespass and structure. To prove the crime of trespass and structure, the state must prove the following three elements beyond a reasonable doubt. 1. Wade Wilson willfully entered or remained in a structure. 2. The structure was in the lawful possession of Fannie Amlin. 3. Wade Wilson's entering or remaining in the structure was without authorization, license, or invitation by Fannie Amlin or any other person authorized to give that permission. Authority to enter or remain in a structure need not be given in express words. It may be implied from the circumstances. It is lawful to enter or remain in a structure of another if, under all the circumstances, a reasonable person would believe that he had the permission of the owner or occupant. Person authorized means an owner or lessee, or his or her agent, or any law enforcement officer whose department has received written authorization from the owner or lessee, or his or her agent, to communicate in order to depart the property in case of a threat to public safety or welfare. Willfully means intentionally, knowingly, and purposely. Structure means any building of any kind, either temporarily or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. First-degree petty theft. To prove the crime of first-degree petty theft, the state must prove the following two elements beyond a reasonable doubt. 1. Wade Wilson knowingly and unlawfully obtained or used or endeavored to obtain or use the property of Fannie Amlin. 2. He did so with intent to either temporarily or permanently deprive Fannie Amlin of her right to the property or any benefit from it, or to appropriate the property of Fannie Amlin to her own use, or to use of a person not entitled to it. 3. The value of the property taken was more than $100. Proof of possession of recently stolen property, unless satisfactorily explained, gives rise to an inference that the person in possession of the property knew or should have known that the property had been stolen. Obtains or uses means any manner of taking or exercising control of the property, or making any unauthorized use, disposition, or transfer of property. Endeavor means to attempt or try. Property means anything of value and includes tangible personal property. Value means the market value of the property at the time and place of the offense, or if that value cannot be satisfactorily ascertained, the cost of replacement of the property within a reasonable time after the offense. If the exact value of the property cannot be ascertained, you should attempt to determine a minimum value. If you cannot determine the minimum value, you must find the value is less than $100. When there are lesser included crimes or attempts. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crime indicated in the definition of first-degree petty theft is second-degree petty theft. Second-degree petty theft. To prove the crime of second-degree petty theft, state must prove the following two elements beyond a reasonable doubt. 1. Wade Wilson knowingly and unlawfully obtained or used or endeavored to obtain or use the property of Fannie Amlin. 2. He did so with intent to either temporarily or permanently deprive Fannie Amlin of her right to the property or any benefit from it, or to appropriate the property of Fannie Amlin to his own use or to the use of any person not entitled to it. 3. The value of the property taken was less than $100. Proof of possession of recently stolen property, unless satisfactorily explained, gives rise to an inference that the person in possession of the property knew or should have known that the property had been stolen. Obtains or uses means any manner of taking or exercising control over the property, or making any unauthorized use, disposition, or transfer of property. Endeavor means to attempt or try. Property means anything of value and includes. Value means the market value of the property at the time of placement of the offense, or that value cannot be satisfactorily ascertained the cost of replacement of the property within a reasonable time after the offense. If the exact value of the property cannot be ascertained, you should attempt to determine a minimum value. If you cannot determine the minimum value, you must find the value is less than $100. Plea of not guilty, reasonable doubt, and burden of proof. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the information through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. Weighing the evidence. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are: 1. Did the witness seem to have an opportunity to see and know the things about which the witness testified? 2. Did the witness seem to have an accurate memory? 3. Was the witness honest and straightforward in answering the attorney's questions? 4. Did the witness have some interest in how the case should be decided? 5. Does the witness's testimony agree with the other testimony and other evidence in the case? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses, with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is only reliable when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. Defendant not testifying. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. Defendant's statements. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to: 1. Whether when the defendant made the statement, he had been threatened in order to get him to make it, and 2. Whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. Rules for deliberation. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. 2. This case must be decided only upon the evidence that you've heard from the testimony of the witnesses and have seen in the form of the exhibits in evidence and these instructions. 3. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. 4. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. 5. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is the judge's job to determine a proper sentence if the defendant is found guilty. 6. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. 7. Your verdict must not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Single defendant, multiple counts. A separate crime is charged in each count of the indictment, and although they have been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged. Cautionary instruction. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. Verdict. You may find the defendant guilty as charged, or guilty of such lesser included crime as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form for each count that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict forms have been prepared for you. They are as follows. In the Circuit Court of the 26th Circuit and in Lee County, Florida, criminal action, State of Florida versus Wade Wilson, case number 19 CF 0568. Verdict. We, the jury, find as follows as to the defendant in this case. Check only one as to each count. Count 1, first-degree murder, Christine Melton. A, the defendant is guilty of first-degree murder. B, the defendant is guilty of second-degree murder. C, the defendant is guilty of manslaughter. D, the defendant is not guilty. Count 2, grand theft motor vehicle. A, the defendant is guilty of theft of motor vehicle. B, the defendant is not guilty. Count 3, battery. A, the defendant is guilty of battery. B, the defendant is not guilty. Count 4, first-degree murder, Diane Lewis. A, the defendant is guilty of first-degree murder. B, the defendant is guilty of second-degree murder. C, the defendant is guilty of manslaughter. D, the defendant is not guilty. Count 5, burglary of dwelling. A, the defendant is guilty of burglary of dwelling. B, the defendant is guilty of trespass. C, the defendant is not guilty. Count 6, first-degree petty theft. A, the defendant is guilty of first-degree petty theft. B, the defendant is guilty of second-degree petty theft. D, the defendant is not guilty. So say we all, a place for the date, for the foreperson to sign their name, and for the foreperson to print their name. Submitting case to jury. In just a few moments, you will be taken to the jury room by the bailiff. The first thing you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict forms when all of you have agreed on a verdict and to bring the verdict forms back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case. Until you've reached a verdict, you must not talk about this case in person or through the telephone, writing, or other electronic communication, such as an email or any other means. Do not contact anyone to assist you during deliberations. These communications rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate, or if you wish to see an exhibit not sent back into the jury room, please request that in writing. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. So with that, ladies and gentlemen, everybody except, well, let me just say, any objection to the instructions is read?
No, Judge.
Okay. Then everybody except juror 445 and juror 269, you may retire to the jury room to begin your deliberations. Juror 445 and 269. I'm sorry? Wait, 1 second. Wait. Sorry. You want to approach? My understanding is you have reached a verdict. All right. You have the verdict form. All right. You pass that to the bailiff. The verdict form appears to be in order. I'll have the clerk publish the verdict.
In the Circuit Court of the 20th Judicial Circuit in Fort Lee County, Florida, criminal action, State of Florida versus Wade Wilson, case number 19 CF 0568. Verdict. We, the jury, finds as follow as to the defendant in this case. Count 1, first-degree murder, Christine Melton. The defendant is guilty of first-degree murder. Count 2, grand theft motor vehicle. The defendant is guilty of grand theft motor vehicle. Count 3, battery. The defendant is guilty of battery. Count 4, first-degree murder, Diane Lewis. The defendant is guilty of first-degree murder. Count 5, burglary of dwelling. The defendant is guilty of burglary of a dwelling. Count 6, first-degree petty theft. The defendant is guilty of first-degree petty theft. Dated 6/12/24. So say we all, 4-person.
All right. Does either party wish to have the jury poll?
Yes, please.
All right. Just my number. Okay. Wait, no.
Yes.
Okay, so.
Juror number 97, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 234, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 3, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 205, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 101, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 215, is this your verdict and the verdict of the jury as a whole?
Yes, ma'am.
Juror 87, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 362, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 136, is this your verdict and the verdict of the jury as a whole? Juror 193, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 315, is this your verdict and the verdict of the jury as a whole?
Yes.
Juror 309, is this your verdict and the verdict of the jury as a whole?
Yes.
Thank you.
So, ladies and gentlemen, what I'm going to do is send you back to the jury room for a few moments. Let me discuss the things with the attorneys, and then I'll bring you back.
All right.
No, just leave everything here. Sorry. Leave everything here for the moment.